Faretta hearing. So you've presented your contract to the attorney who wants to represent you, or the court appointed attorney who works based on the incentive that the acting judge provides that court appointed attorney. And they don't accept your terms and conditions of the contract as you should have done rightfully based on rights of association. Yet, for some reason, the magistrate or the acting judge constantly wants to keep imposing that attorney on you. Yes, you fire them, sure, you do that. But there are other very subtle and very slick things that they will do, irregardless of whether you put it on record. So keep verbalizing the fact that you have the right of association and you're invoking it, and keep firing them no matter how much they might want to keep renewing that appointment, that power of appointment, because they will do it for you. And the reason why they're doing that is because they're engaging in constructive trust. They are deeming you to be their properties. They often they do this if you are within the custody of their police military power. If you're locked up in a county jail or federal jail or whatever entity jail, they will do this very easily because you are deemed to be their property, physically or otherwise, corporeal and incorporeal. Everything that goes with you, they want to take it because that's the business that they are simply in. It's nothing personal. So they will speak on your behalf because, well, they have your physical body as surety, and you're not going anywhere. We determine when you eat, how you eat, what you eat, and what you feel, how you dress, all that. They do that in jail for you because they're all connected. So you are officially deemed a minor because we're feeding you. And in some case, you're compensating us by accepting our proposal and contract while you're in jail to access commissary. So you're a good source of money, you're a good consumer, and you're our child. We're playing the role of parents betrayer. And we're going to use the court system to basically make sure to keep you within the class system, the caste system of you being the lowest of the low. And by doing that, we're going to bring our interest of people who hold foreign title of nobilities to be your spokesman. There's something called Faretta hearing, which is derived from a stare decisis, Faretta versus California. Any type of hearing whereby they use in their favor is often not going to be clear, succinct, or formal, meaning they're not, especially if it's invoked by the acting judge. And oftentimes they will call that acting judge the court. So whenever a specific type of hearing is invoked by the court, most of the time they're not going to set a specific date or a hearing for it. They're going to do it during a status hearing, meaning, okay, what's going on with the current case? Where's everybody at? And that status hearing is a type of hearing that's an open field for any other type of hearing. Whenever you hear the word status hearing, they're telling you anything you want to invoke, anything any party wants to invoke, will be invoked and can be heard right then and there. Although they will make it seem like, okay, we're trying to figure out what are we going to do next. Well, that's exactly what's going on. What they're going to do next is going to be based on what you invoke. So whatever subject matter issue that you have that you need to raise it right then and there, because they do the exact same. That is the purpose and significance of status hearing. And if you haven't formally requested for a motion to be heard, if you haven't moved for the court to introduce certain evidence or certain parties to respond, then the status hearing is where you introduce that and give you the opportunity to extend the time or to do it right then and there through verbal judicial notice, and they will use it against you. And Faretta hearing is one of those things they do. They oftentimes do not formally set it up. So Faretta hearing is basically a situation with a guy who dealt with theft. And he's saying, well, I don't want to be represented by an attorney for whatever reason he might have had. And eventually they deemed him incompetent and unintelligent. So they convicted him. And the opinion says this: the fact of the case is the California Court of Appeal, which relied on the recent California Supreme Court decisions that had expressly decided to issue, ruled that Faretta had no federal or state right to represent himself. Appeal to the Supreme Court of California was denied. That's part of the fact of the case. The opinion of the court. In the opinion of the court by Justice Stewart, the court held that a defendant in a state criminal trial has the constitutional right to refuse appointed counsel and conduct the trial when he or she voluntarily and intelligently, these are the two criteria right here, elects to do so. However, such a defendant may not later complain that he received ineffective assistance of counsel. Even if the counsel did represent the man or woman to their detriment, you still can't. This always applies, because the most an attorney is liable to do is to inform you of your rights and to act as amicus curiae, officer of the court, which is to perpetuate the intent of that establishment, that body politic, which is not in your favor, because you are deemed to be lesser than them, and they are not in the business of whatever they're doing to favor you. Only but very few are. So ineffective assistance of counsel will be denied nonetheless, regardless of whether you're a representative or not. We've spoken about that in the past when it comes to presenting your own contracts to attorneys. It goes on to say the court brought analogies to the star chamber, which is a type of, it's like the judge's chamber, but from the English chancery system, which was transferred here into the Americas. So basically, the judge's chamber. The court brought the analogies to the chamber, saying the star chamber has for centuries symbolized disregard of basic individual rights. The star chamber not merely allowed but required defendants to have counsel. The defendant answers to an indictment was not accepted unless it was signed by counsel, meaning they're basically railroading you because they've privatized the issue because you haven't accessed it using something like a letter rogatoria or an addendum or whatever trustament you want to use. When counsel refused to sign the answer for whatever reason, the defendant was considered to have confessed. Why? Because you are deemed to be a property of theirs, whether they're holding you as surety or not. So you have to come in the proper status and then always challenge your standing and capacity, because if you don't challenge the standing and capacity of that attorney or the person or subject matter jurisdiction, in some case territorial jurisdiction if it's involved in warrants like fugitive warrant, if you don't challenge it, they're deemed to have obtained it, and they're just going to keep on going if you don't talk about it, because it is your responsibility to do so. And part of them having jurisdiction is that they can speak on your behalf and do constructive trust. Simple as that. Part of constructive trust is to do whatever they want with you, regardless of how you feel about it. The key here is always create a specific affidavit. Have you ever read some of these things whereby they affidavits where at the beginning they say, I'm of sound mind and age and competent to make these affidavit of my own free will, etc. Well, that is actually in a way part of things that's done to prevent a Faretta hearing against you. You're making a declaration of competency and intelligence, and you're doing it voluntarily. So create a separate affidavit of competency and the right of association, and invoke the fact that you were voluntarily and intelligently electing not to have any British accreditation registry member represent you, and that you invoke your right to association. That removes the need to do an ex parte against you or to just casually roll over you, because they will do a Faretta hearing on you by just asking you simple questions based on how you respond or based on how you basically put things into the court. They will know whether you're doing things intelligently or voluntarily. So always make sure that somewhere along the line you either state that everything is being done voluntarily and intelligently, and you do in fact structure words and invoke your substantive right intelligently. Don't regurgitate what somebody tells you. Let it come from your spirit. Don't be long-winded, and actually use the substantive laws that they are bound by. Study the codes and statutes, study the rules and regulations, study the rules of evidence. In fact, it's a must. You must study the rules of evidence, because that's how you demonstrate intelligence, not to impress them, but to free yourself. That's how you demonstrate your voluntary action, not to make them feel like, oh, this guy knows what he's doing, but to actually become independent for your own benefit. Study these other things, but make sure you invoke the Constitution properly. So if they think you're not intelligent, or if you can't act voluntarily, they're telling you you're a minor, and we will impose whatever we want on you, and we'll do whatever we want on you. So be very wary of Faretta hearing. They will do things like ask you, are you aware of the federal rules of evidence? Are you aware of the federal the rules of evidence, or the rules of civic procedure? They will ask you these questions. Respond by simply telling them, I'm aware of the constitutional principles and the fact that you swore an oath to it, and everything here has to be constitutional. Any other rules or regulation that you're making reference to still has to be harmonious with the Constitution. So I am aware of the Constitution, and that's irregardless of the fact that you have no subject matter or personal jurisdiction. Let's entertain that first, and we'll be dealing with these matters. It's not your responsibility to litigate this matter and practice law from the bench beyond being a neutral third party. And I am bringing that to your attention in good faith. And I expect you to act in good faith right in your personal capacity. So respond to them appropriately and intelligently. And keep it short and simple and straightforward, however you can. But they will do a Faretta hearing on you by questioning you. And you must put in something on the record that shows that you're acting voluntarily and intelligently, and you are of sound mind and age. And that's when they begin to do things like psychological evaluation on you and things like that, so that they can justify why they are imposing a British accreditation registry member against you, and why they're basically doing a constructive trust on you. So put that notice on the record. And on the note of status hearing, the status hearing is basically like a landmark position within any given case whereby things begin to move. If there is a depiction, usually, I don't know if you've seen it, it's like a triangle where the bottom left, it shows exposition, and then the triangle that's just going up, it shows rise in action, and at the peak is climax, and then at the right of the triangle that's sliding down, it says whatever the hell it is in the end, conclusion, fall in action, then conclusion. So basically, court cases have stages like that, and status hearings are basically checkpoints within hearings, within court cases, that basically shows you and lets you know that, okay, one phase is ending and then the other is about to begin. And oftentimes they code it as pretrial conference or whatever type of conference, and therein is where things occur. Like, they limit the moment any type of status hearing or conference occurs, know that after that point you often can't amend your claims, and that is where it is solidified whether you're competent enough to continue without an attorney or otherwise. Now, if you're really coming right to begin with, they wouldn't even be dealing with you on that pathetic level to begin with. But if they are, that is where they finalize whether they're going to keep one of their members on you and one of their amicus curia or not. So within the Federal Rules of Civic Procedure, this status hearing or conference is within Rule 16. So it shows your purpose of pretrial conference. In any action, the court may order the attorney and any unrepresented parties to appear for one or more pretrial conference for such purpose as expediting disposition, establishing early continuing control, so that the case will not be protracted because of lack of management. This is facilitating settlements to just see what the status of the parties in the situation is. And then the scheduling order is what they issue after that. And usually when they do a Faretta hearing on you by using these status hearings, the scheduling order would oftentimes, if they've decided, because they speak behind closed doors before they put up the show that you think you're part of. They've already decided, okay, after this, the schedule order would be regarding doing a constructive trust and doing a court-appointed attorney, if they are doing Faretta hearing. If not, then the status hearing is usually very, very quick. It usually occurs, if you're doing things right, it would occur anywhere between 15 to 30 seconds. Literally, they would just ask you the names of the parties, and then the magistrate or acting judge is just going to say, okay, well, I see the parties have put this and that in. You have this day to put this in. I'll put in an order letting you know to reply during this amount. And if necessary, we're not going to have another scheduling order if things are repetitive. And then I'll do my filing order. Simple as that. Any questions? Yes or no? Okay, bye. That's usually how it's going to go. If it's going beyond that, then you're not doing something you ought to have done. Because status hearings should not really be long at all in any way, shape, or form. So, time to issue, the judge must issue the scheduling order within 120 days after it, and serve with a complaint or 90 days after any defendant has appeared. That's the time period right there for you. Contents of the order. Required contents like schedule order must limit the time to join other parties. So that's the phases right there. They're telling you they're moving on. And once you do that, the status hearing or the pretrial conference, whatever they call it, that's when they start limiting things, because they're moving on. This is where you get the chance to amend your complaint to join new parties. They tell you, Rule 16(3)(a). Scheduling order must limit the time to join other parties, amend the pleadings, complete discovery, and file motions. Meaning anything else you want to bring, you want to challenge jurisdiction, you better do it now. Although you can always challenge it during, before, and after. But save yourself the headache and bring it up. Let that be your main affirmative defense. So, permitted content. Scheduling order may modify timing, disclosure, blah, blah, blah. Meaning if there's other things that's preventing you from being able to do certain things, you will bring that up now. If the last known address was not delivered and you got return mail, you will bring that up now, so you get the chance to, skip trace and send it to the right party, or just put in a motion saying, well, hey, I've exhausted my efforts, give me a summary judgment. That could be part of the motions to file. You realize, oh wait, I have ability to do the declaratory judgment or default based on Rule 55, 57, all that. Bring that up. They're prolonging things to trial, because that's the whole purpose of things like default, declaratory, motion to dismiss. You bring summary judgment. You bring all that up to avoid trial. You can conclude the case without trial. It's only when the case is not concluded and there's dispute that they try it, because they have to try the sufficiency of the dispute, complaint, or whatever claims is being brought. You don't want to even get to trial before you conclude the case. But nonetheless, status hearing is basically a checkpoint for every case. So they can modify discoveries, include agreements, do settlements, set dates for the trial conference, include appropriate matters. They can modify things, etc., etc. It just goes on and on. So